Hello, everyone. My name's Georgina Jackson. I'm a judge of the Court of Appeal of Saskatchewan. I'm located in Regina, which is on Treaty 4 land and within the traditional territory of the Métis. It's an honor to be part of this conference and to chair this panel. The topic is patriation and the role of the courts. We've touched on this topic throughout the past day and a bit, and now we delve into it even more deeply. We have 4 speakers, 2 political scientists and 2 legal scholars, so this topic will be looked at from both of those angles. I'm going to briefly introduce our speakers. Unfortunately, I can't do them justice in the time that we have. I want you to hear their words rather than mine, so I'll just allow you to put faces to names and occupations and then let them go. So our first speaker this morning is going to be Mark Harding. He's an assistant professor in the Department of Political Science and the coordinator of the Justice and Legal Studies program at the University of Guelph. His main research areas are Canadian politics, comparative law, and politics and constitutional theory. He has a new book entitled Judicializing Everything. Dr. Crandall is an associate professor in the Department of Politics at Acadia University. She holds a PhD in political science from McGill University. Her research joins Canadian law and politics, including studies of judicial selection systems, constitutional amendment, and election law. Colin Feasby is a judge of the Alberta Court of Queen's Bench. Before he was appointed, he was a partner with Osler, Hoskin, and Harcourt. In that capacity, he had an extensive litigation practice, including appearing at the Supreme Court of Canada on a fairly regular basis, including having a role in that court's decision in Frank. He has published numerous articles in the constitutional law area with a particular focus on the democratic process. Jean-Christophe Bedard-Rubin will shortly be joining the Faculty of Law at the University of Toronto as an assistant professor. He's currently completing his doctoral dissertation. His academic scholarship is significant. He has published numerous peer-reviewed articles on responsible government, language rights, and the ethics of constitutionalism. We hope to have a few minutes at the end for questions. Please mark your questions as we go through the various speakers. We won't be taking a break between them. We will gather all of the questions together at the end. So I will call first upon Professor Harding.
All right. Thank you, Judge Jackson, for that lovely introduction. And it's a pleasure to be here and to be on such a great panel with interesting papers and presenters. So what I'm going to be presenting today is part of a larger project that I'm working on related to comparing constitutional negotiations from the 1860s to the 1980s. And so the paper I'm presenting today relates to an aspect of the Special Joint Committee of 1980-1981. And so some of my previous work in this area related to comparing Canada, New Zealand, and the UK, and those 3 jurisdictions' experiences with adding rights-based documents to their constitutions and looking at the changes to constitutional culture in those 3 countries. And through that work, I became interested in this theoretical distinction between what's called political and legal constitutionalism. Through that comparative work, I noticed that Canada didn't seem to be as integrated within some of that theoretical discussion. And so a bit of a pet project of mine is to do some of that work. There are a couple of other people in Canada also kind of engaged in that space. I would acknowledge one of our organizers, Professor McInnell, has done some work in this area as well. And so what my paper does is look at the Special Joint Committee from 1980, 1981, and is an analysis of the Hansard of the participants of those proceedings. And what I do in the paper is look at kind of a textual analysis of the different sort of perspectives of constitutionalism that were being put forward by both the members of Parliament and the various witnesses that participated. And what I try to show in the paper is how this perspective of political constitutionalism was present at the patriation process, and it still persists. It still manifests itself in our constitutional culture and discourse. And so specifically what I do in the paper is to compare the testimony and arguments put forward by those participants most keen on the entrenchment of the charter, and those individuals offering a more skeptical take on the merits of an entrenchment of the Charter of Rights, and that these different arguments map onto this political and legal distinction of constitutionalism. So let me just say a little bit more about that. So to oversimplify a quite broad and rich literature, the basic distinction between these two accounts of constitutionalism is that political constitutionalism, as the name implies, holds that the meaning of rights, that the kind of scope of a constitution ought to be the product of the democratic or elected branches of government. And so this tradition of rights protection is very connected to a parliamentary account of rights protection. And its rival is what's called a legal constitutionalism, or what Mark Tushnet says should be called judicial constitutionalism. And this perspective sees that that rights issues, matters related to the Constitution, are real legal categories, and therefore they ought to really be defined and articulated by judges and courts. And so what I argue in the paper, and this is a point that maybe I should kind of sharpen up, that because my abstract for the paper maybe seems like I'm arguing something else. But what I want to be clear on is I'm not arguing that Canada was a political constitution, and then there's kind of this big bang moment with patriation, and then we became a legal constitution afterwards, based on my research about Canada, but in these other Commonwealth jurisdictions. My assessment is that really most liberal democratic constitutions actually mix or blend both aspects. But that isn't to say that they're kind of, by the mixing, they aren't totally subsumed into one another, that debates amongst judges on a panel, or amongst legislatures, or even amongst different scholarly communities, that we can make sense of the nature of those debates by thinking them as touching on these different theoretical distinctions. So why the Joint Committee? Based on my work and with assistance from some research assistants of going through the Hansard debates, I think that the Special Joint Committee in 1980, 1981 is really an underappreciated moment in Canada's constitutional development. And there's a real rich reservoir of constitutional discourse that people should revisit and take a look at. I want to, if people are interested in this area, I'd really recommend Professor Adam Dodick's book from 2018 on the charter debates. And so it provides a summary of the Hansard debates at the Special Joint Committee. And then what I've done in this paper is gone back and looked at particularly the participants discussing issues around the meaning of rights and the merits of entrenching the Canadian Charter of Rights and Freedoms. And so what I do in the paper is to describe some of these themes that come out amongst the different participants. And so amongst those who are arguing for the necessity, the need for Canada to adopt an entrenched rights document, a couple of and this is not an exhaustive list, but a couple of prominent themes come out in the testimony. Things like the distinction, the difference between law and politics, and the need to sort of elevate law over politics in terms of how we deal with rights. The idea that minority rights aren't really secure if they're left to the whims of legislative majorities, and that courts are better institutionally suited to be the institution that deals with rights issues. And each of these arguments are emblematic of a legal constitutionalist perspective. And so what I do in the paper is to go through these different aspects of the testimony and these exchanges amongst the MPs and senators and the various witnesses giving testimony. And I'm not going to read these passages here displayed on the slide, but this just gives people a bit of a flavor of different witnesses providing those sorts of arguments about that rights aren't secure unless unless legislatures have that check of the judiciary, or that courts are more sort of sensitive and that they can be alerted of a rights issue more easily and more accessibly than legislatures. So that's sort of one side of the debate. And then on the other side of the kind of theoretical aisle that I'm trying to draw attention to, in my going through of the Hansard debate, it seemed to be from my reading that there are actually far more witnesses providing testimony, raising the various sort of trade-offs or kind of problematic issues that might come up with entrenching a constitutional Bill of Rights. From a kind of parliamentary rights discourse point of view. And so again, this is not, these aren't the only points or a exhaustive list of what I talked about in the paper, but just to give you a couple of examples of some of the themes that come up. A number of the witnesses raise issues like, that we already have a system of rights protection, and what this is really going to do is transfer decision making from legislatures to the judiciary. Witnesses making the argument that there's going to be a loss of legislative flexibility by constitutionalizing rights, and that Canada has a rich tradition of actually enacting legislation that provides rights protection, and that legislatures are actually superior at doing this. And then what really comes through in the testimony is a number of people kind of highlighting Canada's tradition of parliamentary democracy and the way that connects public opinion and voters to their elected representatives, and those being the people and individuals to articulate the meaning of our rights. And these are all arguments that really, as I say, kind of dovetail or toggle on to that political constitutionalist point of view. Again, I'm not going to read each one of these passages or these quotes from Hansard, but just to say that there sort of was a plethora of kind of textual evidence for people making these kinds of arguments. And I'll just sort of highlight one of this conference's speakers. So I really enjoyed Professor Russell's presentation yesterday, and Professor Russell testified before the Special Joint Committee, and his remarks really hold up in terms of being really clear-eyed to the MPs and senators about how this change is not going to be a kind of subtle one. This is going to be a very transformative impact in terms of how rights are articulated in this country. And so that very top quote about the final say is one that corresponds to his testimony. And some of the other quotes there are from some of the provincial premiers that were involved. So just to start to wrap up and to make sure everyone else has their time. I'll just end my presentation by making a couple of quick points, which is that what I found really fascinating from doing this research is that it's changed my perspective a little bit on thinking about how these issues have kind of developed in the kind of scholarship around this. As a person who wasn't alive in 1982 and have only read and about these events, the thing that really came through to me in studying this is that I had always assumed that kind of the charter came into effect. It was kind of rushed a little bit, and there wasn't a whole lot of discussion or debate about how it would affect our parliamentary system, and that the kind of the arguments, the kind of normative arguments, the kind of legitimacy debate, as we say in political science, comes up as a reaction to the Supreme Court's jurisprudence of the charter. And what I found by doing this work is that those arguments about those various trade-offs of the effects that entrenchment is going to have on rights were already being thought of and debated and sussed out prior to patriation, and that there were people articulating those points at the Special Joint Committee. So that was something that I learned by going through this, and I think that the different participants are really good spokesmen and women for their various points of view, whether that's those who are very bullish on the need of entrenchment or those raising some of those trade-offs. And so what I try to do in the paper is to show the utility of looking at these debates through this political, legal, constitutionalist set of lenses. And so just to start to wrap up, it's difficult to summarize what's happened in the last 4 decades, but I don't think it would be controversial for me to make the argument that I think the kind of dominant perspective, the kind of main software that most of us run now comes from the perspective of legal constitutionalism, and that courts and the judiciary really are the place where rights get articulated and defined. But I don't think that political constitutionalism, from that point of view, has gone away. And again, I just raise a couple of examples on the slide here about how we continue to have these sorts of disagreements about the relationship between these different institutions and how rights are defined within them. And so the very last point I'll make before I stop is just that kind of the case I'm trying to make with looking at these issues from this kind of political versus legal constitutionalist point of view is that I find it useful for when we're looking at debates between people and it looks like they're kind of talking past one another about the nature of judicial power, the nature of rights or parliament. I find that these two accounts of constitutionalism help to make sense and clarify what at least the nature of the disagreements are. It doesn't resolve the disagreements, but it helps us to sharpen up what the character of that debate is. And so that's what I try to do in the paper. And so I want to thank everyone for listening, and I'm looking forward to the discussion that follows. Thank you.
Thank you, Professor Harding. Thank you for starting us off so well. I will now call upon Dr. Crandall, please.
Thank you very much. Oh, and there are my slides. That's wonderful. And thank you to Mark for getting us started for this panel that I'm so pleased to be able to be a part of. And now I am going to talk a bit about public support for the Supreme Court of Canada and Canadian courts more generally. And I'll just note that this is a project that I'm working on currently with a colleague, Andrea Lawler, who is based out of the University of King's College at Western University. And some of the data that we'll be presenting today is coming from a Shirk Insight Development Grant. And we'll be doing some more work on this. So if people have questions or if there's a thought, gee, I wish we could know more about X thing, we are working on it right now. So please let me know, and maybe we can dig into that thing that you think is important or are interested in. So, patriation, politics, and public support for the Supreme Court of Canada. I'll just start by flagging a question that I think a lot of the people listening to this panel already have an answer to, but nonetheless, it is useful to to note, like, why should we care about public support for Canadian courts? Why does it matter? And of the three institutions of government, I would make the argument that public support is, of course, important for all institutions of government in terms of having a functioning democracy, but particularly so for the judicial branch, because it ties closely into the court's institutional legitimacy. And the court's institutional legitimacy is tied to the effectiveness of judicial independence. So a strong public support is it helps to create judicial independence that has effect, right? And so one of the ways that we know this is that when there is low public support for courts, and this is comparative research, I'm speaking less so to the Canadian case, but low public support is correlated with political attacks on courts. So instances of, sometimes it's called court curving. And so public support is important, not just because it is emblematic of a well-functioning judicial branch and a well-functioning democracy, but also it ties into judicial independence and the strength of the courts to be able to deliver decisions that are controversial or unpopular, but nonetheless correct. And to tie this into our larger discussion for this conference about patriation, we can think about how patriation of the Constitution Act of 1982 has affected public support for the Supreme Court. And we know that the patriation of the Constitution Act of 1982 has fundamentally changed the work of the Supreme Court and other courts. And then when we think about how that might affect the public's relationship with the Supreme Court or its views, certainly the role that the court plays post-1982 is a different one. Some of the decisions that it's making vis-a-vis the Charter of Rights and Freedoms and Section 35 are going to be highly visible, sometimes politically salient, having important public policy impacts. And so it would not be unreasonable to anticipate that that might have an effect on people's views and possibly people's support of the Supreme Court or Canadian courts. And I'll just note at this moment, I'm asking this question, but I'm also not necessarily going to give us a full answer to this question because it's a complicated one, but I can provide some initial data that would suggest that the public's attitudes towards the Supreme Court, Canadian courts, have changed in the last few years. And it's something that we will want to pay attention to and ask these questions of what might be causing these differences in attitudes of support. So I am going to, pardon me, kind of lead in by highlighting some of the key findings that I'm going to be presenting today, in part to kind of help everybody be able to interpret some graphs that might otherwise, on first glance, take a minute to sort through. So I will note that there is evidence that support for Canadian courts is on decline in the last few years. We want to put that in context, that support for Canadian courts is still quite high, very strong, and certainly support is higher for Canadian courts than other institutions of government like Parliament, members of Parliament, provincial legislatures. So it is still on the high end if we're comparing it to other government institutions, but nonetheless, it does appear to be declining. And so this is something, again, we want to be paying attention to and wanting to have data available to know that this is happening. Something that Professor Lawler and I have identified, and this is coming out in an article for the Canadian Journal of Law and Society, I think in the next issue, is that in comparison to previous decades, political party ID matters. So the political party that a person supports does seem to have an effect on their attitudes towards courts, and in particular, supporters of the Conservative Party are less likely to have confidence in Canadian courts. And again, I'll place this in context that the majority of Conservative Party supporters are also supporters of Canadian courts, have confidence in Canadian courts, but they're less likely to have confidence in Canadian courts in comparison to other Canadians. And so if we're looking for evidence of some of the potentially the political effects, right, of the court's decision making, that the Conservative Party supporters are less likely to support the courts, may be one indicator of that. And that Canadians have mixed feelings about the work of the Supreme Court. And there's a couple of survey questions that I'll present during this talk that highlight how, and I'm sure this is not necessarily surprising because people listening to this presentation probably sometimes have mixed feelings about the work of the court, but this does seem to carry over into general public attitudes. And to tie a little bit into Mark's presentation when he was making this distinction between political and legal constitutionalism, one of the ways we might be able to think about this in terms of citizens' attitudes is asking the question, who should have the final say when it comes to conflicts with the Charter of Rights and Freedoms? And 2021, and as it has been in the past when this question has been asked, courts are overwhelmingly preferred over government if there is a law that conflicts, which would, if we were to try to put that into these two frames of legal versus political constitutionalism, certainly fits within that legal frame. And before getting into the data, I'll just provide this context to help us think about support and attitudes towards courts, and in particular, how we might want to puzzle through whether or not the Constitution Act of 1982 may have affected public attitudes towards the Supreme Court of Canada or Canadian courts more generally. And this difference between diffuse and specific support, these are theories of measurement frameworks that have been developed for studying courts in the United States. And there's been a bit of research in the Canadian context that has also tried to look at diffuse versus specific support. And again, some of the research that I'm currently doing with Professor Lawler is also trying to think through these differences and their potential consequences in terms of public support for the courts and also the politics around the courts. So if we were to understand the public support of courts through this frame of diffuse support, it is largely a procedural-based explanation, right? That people's support of the court is rooted in the institution itself and the role it plays, the belief that it is embedded with procedural fairness. People who have a strong support of the rule of law will also have strong support for courts. A strong kind of ideal of democratic values will correlate with support of the courts. And altogether, this understanding of diffuse support, you can think about it as like this reservoir of goodwill in relationship to the courts. And so what that means is that if the Supreme Court makes a decision that you disagree with, and we're worse off because of this decision, you nonetheless still have confidence in the courts, you support the courts because you believe that the role that they play are important and fundamental, and overall the work of the court is good, even if on that specific case and that specific decision you disagree with it. So that's diffuse support. And so what you would expect with diffuse support is that, over the long term, it should be relatively stable. A competing theory, or sometimes framed as a competing theory, but more likely than not, there's going to be elements of both of these things happening. And part of the challenge is to understand how much one particular understanding of support can explain. support of a court in any particular context. So specific support is more of a policy-based explanation. So it's focused on outcomes. And so rather than a person's support or confidence in a court being rooted in something like their attitudes regarding procedural fairness or democratic values, it's based on what that court has delivered in terms of decisions and whether or not that person likes the outcomes of those decisions. So you can imagine in a context where a court makes a series of controversial decisions that a significant body of the population disagrees with, then if with specific support, you would expect support of the courts to go down, right? And part of what specific support is telling us is that politics matters, that we're not looking at the procedures and the fairness of the procedures of the court and its decision, but rather we're looking for what was the remedy, what was the outcome that was provided by the court. And so in those instances, if a court is in a position where it is making divisive decisions, it could put the court support at risk, right? And when we again think about how lower public support is correlated with an increased likelihood of political attacks on a court, we can see how this understanding of public support as specific support could be concerning, and why we would want to look closely at what effects the Constitution Act of 1982 might have on the work of the court and the public's attitude towards the court. So now let's look at some information, and I'll go through this pretty quickly. There we go. So to this first question that I highlighted, how much confidence do you have in Canadian courts? And this information is taken from the Canadian Election Study from 2008 to 2021. The 2021 data is from a module that Professor Lawler and I put together. So we'll be taking some questions from this module and presenting it here today and later on in research. But one of the things that you can see is overall, right, support of Canadian courts is relatively high. If you look at the green and the blue, those are folks who say a great deal or quite a lot of support. But what we can see over time is that those who respond that they do not have very much support of the courts or no support of the courts, that is also increased over time. And I'm going to move forward and break down that information for 2021. So this is information that was taken from fall 2021, and break it down by party identification. And here again, you can see how there is a significant difference between, for example, those who associate with the Liberal Party versus those who identify with the Conservative Party of Canada. And supporters of the Conservative Party are much less likely to say that they have confidence in Canadian courts. Just in the interest of time, I won't get into what's happening with the Bloc Québécois, but throughout these slides, you'll see that the Bloc Québécois does have kind of different attitudes towards the courts and the work of the courts than people who are supporters of other political parties, which is, needless to say, interesting. So, and here we'll talk a little bit about how I mentioned this, that Canadians seem to have mixed feelings about the work of the court. And I'm going to highlight two questions that I think capture some of this. So the first is a question, and again, this is from the 2021 Canadian Election Study. It asks respondents whether they believe the Supreme Court favors some groups over others. And here again, you can see that there are meaningful differences between supporters of political parties, where again, supporters of the Conservative Party are much more likely to either somewhat agree or strongly agree that the Supreme Court favors some groups over others. And so there's a lot to unpack in that statement, but it does signify that there are different attitudes, right, or views about the work of the Supreme Court depending on your particular politics. And that's a telephone. I'll just take it off the hook and go on to the next slide. There we go. And here we see a question of the Supreme Court can usually be trusted to make decisions that are in the best interests of the Canadian people. And here you can see that most people responded that they do believe that is to be the case. So the brown line is somewhat agreed, the dark green is strongly agreed. And you can see amongst people of all political parties that there is this view that the Supreme Court can be trusted to make decisions that are in the best interests of the Canadian people. And so again, we can see this kind of mixed view about the work of the Supreme Court. And again, you can see the Bloc Québécois is a bit of an outlier there. And I have just about 2 minutes left for my time. So we'll go into this question that again ties into the legal versus political constitutionalism frame that Mark presented on. And this is a question that has been asked for a number of years with the Canadian Election Study, this time in this iteration from 2021. And the question of if a law conflicts with the Charter of Rights and Freedoms, who should have the final say, the court or government? And we can see how this also can tie into the conversation about constitutional dialogue. And here again, regardless of political party affiliation, there is a strong view, somewhere around 70% or close to 70% respondents saying that they believe that it should be the courts that have the final say in instances of charter conflicts. So that was a lot of information in 15 minutes. And if there are things that you would like to have unpacked, I'd be very, very happy to answer them during our question and answer period. Thanks very much.
Thank you, Dr. Crandall. Thank you for keeping your time so closely, and your perceptive remarks will guide us in our question and answer period, I'm sure. May I call upon Justice Feasby, please?
Thank you, Justice Jackson. I'm speaking to you today from Calgary, which is on Treaty 7 land, which is the traditional territories of the Blackfoot Confederacy, the Siksika, Kainai, and Piikani, the Tsuut'ina Nation, the Stoney Nakoda Nation, and the Métis Nation, Region 3. My topic today is the Supreme Court of Canada's new approach to charter interpretation. This presentation is a very abbreviated version of a paper that I've written. I tried to post the link to the paper in the question and answer for anybody who wants to download a copy, but if I was unsuccessful in that, you can just find it on SSRN if you just search my name. Over the past 40 years, the courts have produced a body of jurisprudence explaining what the charter means and applying the charter to a dizzying array of factual circumstances. I'd like you to think of this body of jurisprudence as a house. The foundation of this house is the method that courts use to read or interpret the charter. Every charter case, directly or indirectly, is built on the foundation of interpretation. This foundation was laid down in the court's earliest charter cases in the mid-1980s and has until recently gone largely unquestioned. When I went to law school in the mid-1990s, I was taught that the charter was to be interpreted purposively. That is, the meaning of a charter provision is to accord with its purpose. And I was taught that our Constitution was a living tree, capable of growth. The living tree metaphor, of course, was taken from the famous Persons case. My student edition of Peter Hogg's Constitutional Law, which I still have on my bookshelf behind me, said that the court assumed that purpose of interpretation and the generous interpretation taken from the living tree concept were consistent with one another. The court, in several recent cases, has recast its traditional purposivism by placing a much greater emphasis on importance of the Charter's text and circumscribing the role of purpose and context in interpretation. My view is that this is a significant departure from the interpretive method that was the foundation for the last 4 decades of charter jurisprudence. To be clear, as a trial judge, I am agnostic on whether this is a good thing or a bad thing. But the point of my paper is that it is an important thing. And it's something that we should talk about. And it's a thing that may call into question the jurisprudential legacy of the last 40 years. Let me turn to purposivism and living treeism. The court's purposivism was explained by Chief Justice Dixon in Big M Drug Mart. He said that, quote, "The purpose of the right or freedom in question is to be sought by reference to the character and the larger objects of the Charter itself, to the language chosen to articulate the specific right or freedom, to the historical origins of the concept enshrined, and where applicable, to the meaning and purpose of other specific rights with which it is associated in the text of the Charter," end quote. He went on to say that purposive interpretation was to be, quote, "generous rather than legalistic," end quote. The idea of interpretive generosity, again, comes from the living tree metaphor. Shortly after Big M Drug Mart, in a case called Reference re BC Motor Vehicle Act, the court explained that the subjective intentions of the framers of the Charter were to be given little weight in interpretation. So there we have it. That's the interpretive method for most of the first 40 years of the Charter. It's a list of ingredients. It is not a recipe. A recipe also provides directions as to how to combine the ingredients. And when you give a cook a list of ingredients instead of a recipe, the cook has a lot of discretion. The judge is the cook in this analogy. So why did the court pick a highly discretionary interpretive method? There are 2 reasons that emerge from the case law. First, the court rejected the so-called frozen concepts interpretive method that had been used for the Canadian Bill of Rights. And second, the court rejected the substantive intentions originalism that held sway in parts of the U.S. Conservative Legal Academy in the 1980s. The justices rejected these restrictive methodologies, which it must be said bear some resemblance to one another, and took the view that they had been entrusted by the framers to interpret the Charter using their best judgment. Let me turn now to what I call the textualist critique. Over the past 10 years or so, there has been a growing crescendo of criticism of the court's interpretive method. The criticism comes from a group of judges, professors, and practitioners that for convenience I call the Canadian textualists. 2 of them, Bradley Miller and Grant Huscroft, are on the Ontario Court of Appeal. Another, Professor Sirota, just happens to be on the panel that is running concurrently in this conference. The Canadian textualists take their inspiration from what may be called New Originalism. New Originalism is ascendant in the United States right now and has 2 basic premises. 1, the constraint principle, which holds that the text of a constitution constrains its meaning. And 2, the fixation thesis, which holds that the meaning of the text of the Constitution is fixed at the time of its framing. And the meaning that is fixed is not the meaning subjectively intended by the framers. It is the original public meaning. New Originalism is said by its proponents to be preferable to purposivism and living constitutionalism because it limits judicial discretion. Judicial discretion is problematic from this view because it is anti-democratic, because judges are unelected. Perhaps the most important article by a Canadian textualist is Benjamin Oliphant's article in the UTLJ from about 6 years ago where he articulates a textualist version of purposivism. I say this because the court expressly endorsed Oliphant's approach to purposivism. This is not to say that the views of other Canadian textualists have not been influential. They have. Oliphant's key points are as follows. First, the text defines the outer boundaries of charter rights. Second, purposivism is a method to narrow, not expand, the meaning of the text. Both of these points have been accepted by a majority of the court. Oliphant's approach calls into question existing jurisprudence. Indeed, he acknowledges this, pointing to the Section 3 right to vote jurisprudence as being ripe for reconsideration. So let me turn to the court's new approach and what the court has said. The court's new approach emerged in a series of cases between 2019 and 2021. These cases are Poulin, Stillman, 91470732 Quebec Inc., and City of Toronto. Unfortunately, we don't have time to discuss all of these cases in detail. The majority in the Quebec Inc. case asserts that, quote, this court has consistently emphasized that within the purposive approach, the analysis must begin. The words must begin are italicized. Must begin by considering the text of the provision, end quote. The use of italics on the word must begin reinforces the mandatory nature of the direction. The court continued saying, quote, constitutional interpretation being the interpretation of the text of the Constitution, again, using italics, must first and foremost have reference to and be constrained by the text. Again, the majority is using italics to drive its point home. And then, quoting Oliphant, the majority explains that the written words are, quote, the most primal constraint on judicial review and form the outer bounds of purposive inquiry, end quote. This new approach was then applied in City of Toronto and labeled purposive textual interpretation. So I would suggest that we have a name for this new method of interpretation, purposive textual interpretation. City of Toronto, of course, also emphasized the importance of text by finding that unwritten constitutional principles are not independently enforceable and are simply an aid to interpreting written text. There are also hints in the Poulin and Stillman cases that the court may be open to a greater use of history in defining charter rights. Professor Sirota suggests that this resort to history is consistent with the techniques of public meaning originalism. So now I'm going to turn to the potential implications of this new interpretive method. Whether or not the new interpretive method will result in a large-scale reappraisal of charter jurisprudence depends on the court's view of the principle of stare decisis. In other words, how much they will respect precedent. Justice Scalia famously said that he was a faint-hearted originalist because he accepted that some precedents must stand despite not being based on originalist reasoning. Justice Amy Coney Barrett, by contrast, has said that justices must enforce their best understanding of the Constitution. Many speculate that with the prospect of Roe v. Wade being overturned this term, that Justice Barrett's view of stare decisis will prevail. That same debate over stare decisis exists in Canada, with the Bedford case holding that the court should enforce its best understanding of the Charter rather than adhering blindly to precedent. So here are 4 areas where either courts or academics have identified alternative textual approaches to charter provisions. So these are not my ideas. These are ones I've taken from existing case law or from academic literature. First, Justices Brown and Cote advanced what they considered to be a more textually faithful, and those are their words, reading of Section 1 that is inconsistent with Oakes in their dissent in the 2019 case, Frank. This is noteworthy because Oakes is probably the most important and entrenched charter precedent, and yet we have two justices that are prepared to depart from it. Chief Justice Wagner, writing for the majority in Frank, rejected the approach on procedural grounds because it had not been argued by the parties. But the issue may return in a different case if the parties put it before the court. The next example is the Hills case. Hills was argued in late March of this year. The issue in Hills was whether mandatory minimum sentences can be cruel and unusual punishment under Section 12. Justice Wakeling in the Alberta Court of Appeal applied a textual and originalist reading of the term cruel and unusual in his concurring judgment. Before the Supreme Court of Canada, the Attorney General of Ontario argued Wakeling's position in its intervenor factum, and the issue was joined by some other interveners. Marshall Rothstein, in a speech and article published shortly after his retirement, identified the court's recent freedom of association jurisprudence, so that's Charter Section 2D, cases that constitutionalize the right to collective bargaining and the right to strike as being examples of straying too far from the constitutional text. There are academics who have made similar points. And lastly, of course, we have Oliphant, who identified the Section 3 right to vote jurisprudence, where the court identified the derivative rights of effective representation and meaningful participation as being an area that should be reconsidered because of the departure from the text. Specifically, neither effective representation nor meaningful participation appear in the text of Section 3. So, the big questions that remain are, what exactly are the parameters of this new interpretive method? Is it just a more structured and revised form of purposivism, or is it something closer to originalism? And does the new interpretive method imply a large-scale reappraisal of the last 40 years of charter jurisprudence? I don't have the answers to these questions. I think all of us are just going to have to stay tuned to see what the court says in the coming years. Thank you.
Thank you very much, Justice Feasby. It's unfortunate that all of our speakers don't have more time to cover these topics, but I'm sure when you consult their papers, you will be able to explore their opinions more deeply. May I now call upon Professor Bedard-Rubin, please?
Superb. Okay, thank you very much, Justice Jackson, for the introduction. Thanks to the organizers and to the presenters as well. This is a super panel, and I'm really delighted to be part of it. So it's really nice because I think the themes that we cover dovetails well with one another. So what I'm going to talk about today is one recurring fear that I see in Canadian constitutional culture. Just have a problem with my slides. Excuse me. There we go. Okay. So one recurring theme, I say, of Canadian constitutional culture, which is the fear of the Americanization of the Canadian way of going about their constitutional system. It's an enduring fear in the history of Canadian constitutional law. And what I suggest to do is focusing on precedent as one place where we can see either a convergence or a divergence between Canadian constitutional law and American constitutional law. What I suggest to do is looking at three elements. First, the enduring fear of Americanization that is present in Canadian constitutional culture, at least since the 1960s. The way in which, since the adoption of the Charter, Canada and the US have diverged in adopting what I call different regimes of constitutional historicity. That is, how much weight they give to the past, how useful they think the past is in constitutional adjudication, especially in the context of rights, and how much normative weight should be given to previous decisions. And I will conclude with some brief remarks about the tension that might be at play in Canada between elite and popular constitutional culture. So in the 1960s, Canadians were trying to understand what had been going on for the last 100 years since the adoption of the BNA Act. And many wondered how Canadians would go about redefining their own identity, now that they were moving away from the British reference and this old Commonwealth identity to a more continental self-definition. People like Will Morton in The Canadian Identity or George Grant in Lament for a Nation warned Canadians that Uncle Sam had its arms wide open and that they would lose something if they were to adopt the American way of doing constitutional law. That they had to preserve, in a sense, the British moderation that had been a characteristic of Canadian constitutionalism for 100 years. Even people like Pierre Trudeau, for example, in Federalism, the French Canadians, sang the same tune. Trudeau wrote, perhaps a little bit surprisingly, he said, "I am inclined to believe that the authors of the Canadian Federation arrived at as wise a compromise and drew up as sensible a constitution as any group of men anywhere would have done. Reading that document today, one is struck by its absence of principles, ideals, and other frills. Even if the regional safeguards and even the regional safeguards and minority guarantees are pragmatically presented here and there rather than proclaimed as a thrilling Bill of Rights. It has been said that the binding force of the United States of America was the idea of liberty, and certainly none of the relevant constitutional document let us forget it. By comparison, the Canadian nation seems founded on the common sense of empirical politicians who had wanted to establish some law and order over a disjointed half-continent." Now, this is somewhat surprising coming from the same person who suggests adopting a Charter of Rights, entrenching rights in the Canadian Constitution as part of his People's Package later in the 1970s and 80s. And to many who had warned about Americanization in the 1960s, it seemed that the People's Package of Pierre Trudeau was the final nail in the old Canadian coffin. Now, 40 years later, what is the verdict? Well, the jury is still out. Some people like David Schneiderman or Samuel LaSelva have written recently saying that there's still something distinctly Canadian about the way in which rights are adjudicated and about the way in which Canadians go about their own constitutional system that is markedly different from the American model. And those who praise Canada's dialogic model of constitutionalism or the new Commonwealth model of constitutionalism also suggest that between parliamentary supremacy and judicial supremacy, there is some form of hybrid that's possible, embedded in the Canadian Constitution. And that this would be the perfect harmony between the two. Now, what I suggest doing is moving from these spatial metaphors to temporal metaphors and trying to understand how the judiciary has redefined its role in the history of Canadian law since the adoption of the Charter, by focusing on one of the three internal constraints to judicial power. So Walter Murphy, one of the pioneers of the study of judicial behavior, said there are three limits internal to the judicial system about judicial power in the US. Courts cannot initiate proceedings themselves. They're limited by Article 3 of the Constitution, which restricts their jurisdiction to cases and controversies. Justiciability, which means who can get their cases heard and when, restricts the ability of court of hearing any case they want. And stare decisis makes precedents binding on the court's interpretation of the Constitution and other rights. Now, notoriously, Canadian courts are more easily accessible. The executive, either provincial or federal, can ask court-specific questions in their reference powers. Justiciability has been weakened in Canada since the adoption of the Charter, with the court revisiting its jurisprudence on ripeness, mootness, political question, standing. And the third element that I would like to focus on is precedent, as one of the three elements defining the scope of judicial power, at least as it's seen in American eyes. The contrast between constitutional precedents about rights in Canada and the United States is striking. Constitutional precedents have been foregrounded in all constitutional discourse, in all constitutional disputes in the US in the last 40 years, while they've played much more of a background role in Canada. In the United States, when judges are appointed or nominated for the Supreme Court, for example, they're questioned extensively about what they see as being super precedents. That is, cases that would be beyond reconsideration by the court. Cases like Brown versus Board of Education, Griswold v. Connecticut, Loving v. Georgia, and sometimes they're even asked about Roe v. Wade. Because super precedents inform the dominant meaning of the whole American constitutional project. And judges rely on those cases to give meaning to their adjudication of contemporary disputes. But even when courts decide to depart from precedent, they've done it in a distinct way. For example, they say that a case that's overruled was wrong the day it was decided. In Lawrence v. Texas for Bowers v. Hardwick, and Trump v. Hawaii for Karamatsu. As if two cases cannot coexist side by side if the holding of the court is different in both of them. The court cannot simply go about its business and say, things have changed, that was then, this is now. But in so doing, the court does something specific. It's recovering a meaning that was already there, but that was lost at one point in the past. They're using previous cases to show that there was another understanding of the unfolding of the American constitutional project. They use previous precedents and their configurative force that they give to the American constitutional narrative to reinterpret what the correct unfolding of the American constitutional project is. And in that sense, they deny that they have any judicial agency. And they interpret the Constitution in strict separation of powers terms. And they present themselves as umpires who simply call balls and strikes. They have no role to play in carrying the constitutional project forward. They simply hold politicians to account to principles and standards that were there already either in the precedents of the courts or in the constitutional text. Now, Canadian courts have done things very differently. When reconsidering their previous charter rulings, for example, in cases like Burns, like Bedford, like Carter, they've mostly avoided reconsidering explicitly the bindingness of their previous decision. And these cases, for example, were unanimous. So adherence or not to precedent is not used as a tool to attack the majority or the minority for their adherence or lack thereof to constitutional precedent. The court simply says that things have changed since our last decisions and we've moved on. We can reassess that case in light of new evidence and move along. And of course, it's much easier to do this under the principle of proportionality, which is the lens through which the court assesses limitations on constitutional rights. Proportionality distinguishes between the scope of the right and the assessment of its limitation and the justification of that limitation. While categorical interpretation in the United States brings those two steps together so that every reassessment of the limitation of a right looks like a reinterpretation of the scope of that right. While when those two steps are kept separate, as is the case in Canada, it's much easier to keep the old interpretation while reassessing its limitation in light of new evidence. And finally, the court has been evolving in a story about the Canadian Constitution as a constitution that's not finished yet. A constitution that is a living tree, that is moving forward, and that might reach some stage of completion at one point in the future, but that this has not happened yet. That the Canadian Constitution is, in some sense, an unfinished project. And in this respect, that Canada's past is only modestly usable for adjudicative purposes. And of course, the rounds of mega-constitutional politics that have followed the adoption of Patriation, because Quebec didn't sign Patriation in 1982, and the increasing recognition of the need for a change of some kind of constitutional magnitude for reconciliation with Indigenous peoples in Canada, lead the court to look forward for potentially a finished constitution that might occur at one point in the future. For Canada to have finally its founding moment, but at one point. That until then, we're still living in some kind of constitutional prehistory. To use Cheryl Saunders' words yesterday in her keynote speech, that patriation might not be over yet. Now, I think that this tells us something about the relationship between elite constitutional culture in Canada, of judges and politicians, and how they see their role in the constitutional order, and popular constitutional culture. That is, how charter Canadians, as Alan Cairns called them, understand their own constitutional institutions, the kinds of standards that they hold public officials to, the kind of accountability structure that they expect. And when they make their claims, that they make their claims in some kind of definite interpretation of rights, some absolute conception of rights. While judges and politicians, in some sense, continue to adopt this accommodationist understanding of self-moderation that guides, or that used to guide at least, the old model of the British Constitution that people feared would be lost in the 1960s. In some sense, it seems as if, in the way in which judges have redefined their role, accepting that the constitutional project was still moving forwards, and that they might have to raise awareness about rights infringement, but that they would not stand in the way of politicians making that constitutional project move forward. Judges were simply reconducting this idea that the Canadian nation is founded on the common sense of empirical politicians. Now, I think that the question that this raises is not whether there has been an Americanization of Canadian constitutional culture since 1982, but rather to see that there's a disjuncture between this older British way of doing constitutionalism that's still present through the understanding that the court has of its role, and the more boisterousness of American right stock that is sometimes used in popular constitutional discourse. And this tension, I think, sheds some light on the way in which we've experimented with constitutionalism since 1982. Now, is it a good thing or a bad thing? Does it imperil the stability of the Canadian constitutional system, or does it breathe new life into it? I think is a question for another day. Thank you.
Thank you very much, Professor Bedard-Rubin. May I ask all of the panelists to come back in? And we have about 20 minutes for questions and comments. We have a couple of questions in the chat box, and I have a couple of questions for the panelists. And perhaps while we're waiting for some additional questions, I will lead off with a question first to you, Justice Feasby, picking up on where you were ending off with certain charter rights that might be vulnerable to a re-examination in a textualist sense. And in your paper, you mentioned effective representation and the 1991 decision of the Supreme Court of Canada that used that phrase for the first time. Do you think that if you pull together your thought regarding stare decisis as being part of a textualist view, do you think that for a Canadian scholar as compared with an American scholar, would they have a different perspective on effective representation or that line of cases? Is it less or more vulnerable to review? What do you think the scholars would say on that?
I think that there's a path for a textualist court. This is making an assumption that we have a more textualist form of interpretation now. I think there's a path for a textualist court to do a couple of different things. One, the court could keep the concepts of effective representation and meaningful participation And they could do so by using the unwritten principle of democracy as an interpretive aid, as the City of Toronto case allows, as an interpretive aid to give content to Section 3. Now, a textualist court wouldn't frame effective representation and meaningful participation as rights per se. They would just simply talk about them as informing the content of the right to vote. There is an argument that I put in the paper that you could make a case that a different approach to interpretation should be taken in the context of Section 3, because there is, and political scientists and so forth have talked about these sorts of things for many years, that there's this structural conflict of interest when the legislature is making rules for the political process. And there may be room for a more active court in the context of Section 3 to regulate or police the political process. But if a court was really committed to saying, we don't like these unenumerated rights, I'll use that term, of effective representation and meaningful participation. And Professor Daywood at University of Toronto calls the Section 3 a plural right because it includes these derivative rights. If a textualist court didn't like that, you could still see the court performing its sort of regulatory role in the political process by asking, what does the right to vote or the right to stand for election, what does it imply? What does it necessarily imply? Because it has to be more than the bare formal right. And I say that because if it's only the formal right to vote, you could have a Soviet-style democracy where everybody has the ritual of voting, but there's no meaning to it, right? So it has to imply something. Well, what does it imply? Well, it presumably implies that the votes are of roughly equal value, right? Because you can't have a democracy if you have wildly disparate weighted votes. Presumably, it would imply that candidates are to be treated equally by the law. Maybe there's other things that it would be implied, but in the paper, I raised those ideas.
Thank you for that. If I could come back to Professor Bedard-Rubin, do you have any comments on that line of issues, or where would you, do you think there are some constitutional precedents that are more easily protected by the doctrine of stare decisis in Canada?
Yeah, that's a good question. I think one thing that's interesting is how the attitude of the court with regard to rights precedents versus federalism precedent has been very different. So I'm focusing mostly on what I was saying on rights issues, Charter of Rights, mostly Section 2 rights. But for example, recently in the Como decision, the court was really reluctant to revisit to accept any kind of social scientific evidence or historical evidence to reinterpret the meaning of the Constitution Act 1867, while it's been much more open to this kind of reinterpretation of its own case law in the context of rights. So I think there's a difference between, one might say, the Constitution of, some Sanford Levinson said, the Constitution of Settlement and the Constitution of Conversation. So the kind of basic structural features around which political life is regularly organized, division of powers, etc., the court might be more reluctant to revisit its case law. But when it comes to Charter of Rights, I think that the court is accepting its role as being the most enabling rather than the most constraining, raising awareness without standing in the way of politicians having to go about their business.
Thank you for that. So I'm just going to take a question from the chat, and it's directed to Dr. Crandall, and it's about the way in which one of your questions was phrased. The question is whether, by asking whether a law conflicts with the Charter, does that bias the results somewhat? And the questioner goes on to say use of the notwithstanding clause doesn't necessarily conflict with charter rights, but only with Supreme Court interpretations of the charter. So wondering whether perhaps if you would ask the question this way, if the court and the Supreme Court of Canada conflict on a charter right, who should have the final say?
Mm-hmm. Yeah, this is a really excellent question about wording of survey questions. And of course, the way you ask the question will potentially bias the response. And I always kind of smile with this question, like the idea that a law professor would get asked this survey question, and it's oversimplified, and they would say, "Well, give me the context. It depends," and all that. Of course. So the value of this question, I will say, is that it's been asked by the Canadian Elections Study over multiple iterations. So what you will be able to capture is change over time. So it's longitudinal data, and this has value for us to understand changes in people's attitudes regarding the courts and in government in terms of right disputes. But to this, very important point, what exactly is it capturing? I think with a question like this, because it is a complicated relationship, I think that is a really fair point to make. So we would want to, in the interest of social science research, keep the question because it's been asked over 20 years or so. But also with the research that we're doing right now, we have the opportunity to do original surveys and to ask some questions that maybe are able to look at this in a more developed or nuanced way. And I'll just note that we did, for the 2021 survey, put out a question regarding people's attitudes on the notwithstanding clause when there is a conflict. And one of the really interesting things is that there is division in, as you would expect, the public's attitude on the use of the notwithstanding clause. But the thing that stood out most for me was that the largest group of respondents, about 25%, said that they didn't know when they're asked, would you want a government to use the notwithstanding clause when they disagree with a court's decision? So about 25% responded, I don't know, which would indicate, right, what we would think instinctively, right, that a lot of people don't know what the notwithstanding clause is and how it works and what the implications are in terms of its the relationship between courts and government, courts and legislature. But I think seeing such a large group of respondents say I don't know to a question on the notwithstanding clause probably tells us a lot about this question that we spend a lot of time thinking about and talking about.
Thank you. So, Professor Harding, you mentioned in one of your last slides about the dialogue between legislatures and the courts. It seems to me at one time, judges, scholars were regularly talking about that and trying to provide content for that notion. Do you think that we should pick up those issues again, or that issue again, as a means of better explaining the tensions between the theories that you've developed?
Thank you for that question, Justice Jackson. And so I'm sure there could be a couple of people watching our conversation, and the use of the term dialogue can be kind of triggering for people who have spent a lot of time reading and studying and the debates about the metaphor. So I guess kind of quickly on kind of came into existence, it was used by the court, and the Supreme Court of Canada has gotten away from using it. And in terms of why that happened, and I'll just reference some colleagues' work like Emmett McFarlane and Professor Mathen's work about this, which is that the term, when the court uses it in recent years, or when it used to use it more, it was fine when the court was using it descriptively, like to kind of describe how the Canadian system operated. But then when some judges would insist that prescriptively, that we need to decide this case because there's a dialogue between courts and legislatures, so we need to rule X or Y or Z, then the judges would start to get into conflicts interpretively over just because someone wrote an article that we liked and we like the metaphor, does that really bind the hands of how the court needs to address constitutional interpretation? And this obviously touches on some of the other things that the panelists have touched on. So I guess what I would say is that I think we need a term, whether people are sick of the dialogue metaphor. We're going to keep talking about the relationship between courts and legislatures. And there's a kind of internal or kind of meta debate over, should judges think like legislatures as well? Should that be part of their role? And as Professor Crandall knows, political scientists don't get to ask judges questions very often. And so we have a trial court judge and an appellate level judge on the call here right now. And I guess I imagine there will be some judges, not to put you on the spot, that would be reticent or squeamish about part of their interpretive role of having to think like legislatures, that maybe judges are more comfortable saying, I have a role, the legislature has a role, and I will, stick to what I think my constitutional position is. And so there's a role for kind of theorists and scholars to interpret that. But and so I don't know if either of the honorable judges on the call want to follow up there, but because I know I'd be curious to know what the answer is.
As a general rule, Professor Harding, panelists don't get to ask moderators questions. So I'll just ask in the interim while I'm thinking about whether or not I'll answer, whether anyone else has a comment that they'd like to make about that, or any aspect of what was said today on our topic, patriation in the courts. We have a few minutes left, and there aren't any more questions in the chat box, although I do have a couple to come back to. Any comments?
If I can ask a question to Erin, because I feel this is fantastic work. It's good that people are picking this up, because there's few of that's been done in Canada. So it's good to see that some people are doing it. And one of the things that I always think when I'm reading the newspaper is, where do people get their ideas of the court from? And my question is always also, what do we ask? Do we ask about the court or the courts? And these seems to be very different questions with very different implications. And if you're reading the newspaper and you hear about criminal trials and first instance decision, it's a very different kind of perspective that you might have on what courts are doing compared to what political scientists and people interested in the political process think of the court as the Supreme Court deciding these big political issues. So I'm just wondering, how do you tease out, let's say, these two kinds of dimensions of what courts are?
Yeah, that's such a good question. And it also speaks to kind of the lack of data that we have in Canada on this topic, that we, up until this point, we can't even really parse it out. So the Canadian Elections Study typically asks the question of, do you have confidence or support in the courts? And you're right. So what does the courts mean? And what are you thinking of when somebody prompts you with the courts? Because I probably think about the Supreme Court just by the kind of some of the nature of what I study and what we study, but I'm not typical. So one of the questions that we did ask in this module for 2021 was a question along the lines of, when you hear somebody refer to the courts, what is the first court, or what is the court that you think of? And the answer was, and it was something like around 60% or so said provincial courts. So I think this is important when, as we move forward with our research, is that when people are thinking about the courts, most are thinking about, so to the point that we have two judges on our panel today, they're thinking about provincial courts. And I think this will matter when we're trying to suss out what's driving support for courts, right? We need to be thinking about what courts are we talking about, and this could then matter for the province of the respondent, because what judges are doing in one part of the country might look different or be talked about differently. So we're getting into questions of federalism as well. So it is something that we're thinking about, but the initial data suggests that most citizens are thinking about lower courts when they're thinking about the courts.
Thank you, Dr. Crandall. I think coming back to your question directed to Justice Feasby and me, Professor Harding, I think it's fair to say that the courts are concerned or would be concerned when looking at Dr. Crandall's research, to think that there is a decline in respect for the institution. So I think the courts would want to ponder that issue and explore it. What can be done is perhaps a question I put back to Dr. Crandall, whether or not her research shows anything that the courts should be doing here differently. Is that an area of research that or thought that flows from your statistical work?
Yeah, so I think going back to the conversation about diffuse support versus specific support, a part of it will be trying to unpack these two things in the case of Canada. And if we see that support is being driven, for example, largely or significantly by a specific support, that can be concerning, right? If you're a judge, to know that the support that the public has for your institution is in part premised on the decisions that you make, knowing that public attitudes around a particular issue should not be informing the decision that a judge makes. So if we find that specific support is something significant, then that potentially affects, the thought process of judges, knowing that. What you want to see in a healthy democracy is like this reservoir of goodwill, as the literature calls it, right? Diffuse support, that even if you get these decisions that you don't like as a citizen, that nonetheless you support the institution, recognizing that it is kind of a fundamental feature of a democratic system. So that's part of the way we're going to try to unpack that. And my own kind of instinct right now is that, citizens learn about the courts and the work they do by and large through the media. And so part of what we'll be doing also is a media analysis to look at how courts and courts decisions are covered by the media, because most people do not, have the opportunity to go into the courtroom, or not reading a court's decision or watching it, live on YouTube or whatever. So I think part of it will be understanding what the media is doing as well.
Thank you. We have another question. And this one is whether the patriation process was too influenced by lessons from and interactions with the United States, rather than taking more account of other places in the world from which drafters might have drawn more different ideas. Maybe Professor Bedard-Rubin, would you like to lead off on that?
Yeah, I can try. It's a big question, but definitely. So it's interesting to read some of the material that Mark covers as well in his research, which is, it's kind of attraction and repulsion, and it's never quite clear. Like, it's embrace, making sure to avoid the perceived problems of the American constitutional system, but at the same time, the remedy is not a forward-looking remedy. It seems to be like backward-looking to American case law in the 1960s or 70s. So it's difficult to say if there was too much influence, but I think that one thing that's important, I think, is to recognize also that Canada is not just a variation on an American style light. It's something different. It has a bit of American influence. It has some of the post-war paradigm that some people talk about, with inherent limitations on rights instead of absolute rights talk that's characteristic of American constitutional law. But it's difficult to understand what's been going on, at least in the first year of the Charter, I would say, during the adoption, and afterwards probably the case law for the first 10 years. It's hard to understand what the court is doing, as Justice Feasby was referring to, the early charter cases were, without mentioning it, in discussion with originalism in the U.S. So I think is there too much or too little of it? It's a hard case, let's put it like this. But there's definitely a lot of it that we need to understand what's going on in Canada.
Good question and good answer. Justice Feasby, maybe the last word to you.
Sure. We can debate whether there's too much or too little American influence. I think usually the debate's about whether there's too much. But I think I can't remember which politician, it might have been the first Trudeau, who said, it's like sleeping next to an elephant. And in a legal sense, the United States, their constitution in the time, in the late 18th century, was innovative. It's become incredibly influential around the world. They have an incredibly litigious society, which generates an incredible amount of jurisprudence, incredible amount of legal academic analysis of it. And I think, it's impossible for Canada to exist, in splendid isolation from that. And so we are constantly borrowing, reacting to, rejecting American ideas. And obviously there are other influences as well. But I don't know if it's that productive to spend a lot of time worrying about it. I think it's just a fact.
Okay. Thank you very much. It falls to me to thank each and every one of you for your splendid presentations today. It's been a pleasure moderating this session, and thank you, each of you, very much. Good day. I think the next panel will be in about 15 minutes, and there's a break. So good day to you all. Bye-bye.